Our topic today is talked about the laws of estate planning and a few other considerations with estate planning. First thing is the laws of estate planning include many various parts of the law that we have. Generally, we think of estate planning as writing a will. However, that's only one part or one small law that we deal with when we do estate planning, because when we do estate planning, we talk about the orderly transfer of property from one generation to the appropriate beneficiaries or the appropriate heirs. Before we even get started with the estate planning process, we first have to look at the property ownership. Now, most of the time I deal with married couples, and because of the clients are married or the people are married, we're concerned about, do they have community property or separate property? And if they have either community or separate property, to meet the person's objectives, do they want to keep it as community or change it? Or do they want to keep it as separate or change it into community? Let's look at this first. The default of community property rules is once a couple becomes married, all of their property is community property. That's the general default rule in the law. If either party wants to claim it's their separate property, they have the burden of proving it's separate. Well, how do you determine whether it's community or separate? Well, all property is community unless either spouse can claim it's mine or my separate property. There are three ways to get separate property. The first is the property you had prior to the time you got married. That is separate property. Also, separate property includes the property that you've received by gift, even though you were married. And the third type of separate property is property you received by an inheritance. If neither spouse can say that the property theirs when they're married that was owned by either party prior to the time they got married, or received by gift, or was received by inheritance, the default part of the law says this is community property. Now, sometimes we have couples that have community property and for some reason or other wish to separate it into some of it his separate property and some into her separate property. The general time you do this is for asset protection purposes. And we can have agreements between the spouses that do this, so we can change the property characteristics from community to separate. And also, if we've got separate property and we wish to have it become community property, we've got provisions in the law that allow to do this. Why would they want separate community property rather than separate? And this is an income tax reason, if the property is going to be sold, because community property under our income tax laws get a step up in basis on both the decedent spouse's half of the property and the surviving spouse's part of the property. Well, doing that, we can save income taxes with a properly planned estate plan. The next thing we worry about is the probate law. How do you pass the property along? Well, there are 4 ways to pass property, and we'll talk about those a little bit later, but the probate law is generally what we look at to think about to start with. When you write a will, you name an executor, you put in the people that you want to take what part of the property, and then sign it with the formalities required by the law. Third type of thing we look at, and a major part of the law we're going to discuss, is trust law. Why? Because a trust is probably one of the most powerful estate planning tools we can use in Texas. Why is that? Because we can use a trust to save taxes, protect assets from creditors' claims, and to protect assets from the vagaries of life. The third thing we use is what I call operation of law. There are several laws in effect that say the way we take title to property is how it will pass upon our death. Generally, we think of bank accounts. Between married couples, we take a bank account as joint tenants with the right of survivorship. Very easy to do. All a married couple has to do is go into any bank, savings loan, or other financial institution and say, we're married, we would like to open an account here. And in general, probably more than 90% of the time, the financial institution would open an account for husband and wife as joint tenants with right of survivorship. Why is that important? Because upon the death of either husband or wife, all of the property ownership vests in the surviving spouse. Now, a lot of you folks will say, hey, that's really good. That's what we want to happen. But is it really, particularly if you want to get some asset protections that we'll talk about later, or some tax savings, which we'll also talk about later? Next time we talk about is contract law. There are certain contracts you can enter into during life that affect the estate planning thing. Generally, we think of selling the property, and a lot of people, when they sell property, they wish to take back a note, so they want to sell it on the installment sale basis to save capital gains taxes in the year that they sell it. This is an excellent planning tool to save income taxes. However, the installment sale contract does not receive a step up in basis or will not save any capital gains taxes. If the couple owned the property until the first spouse died, they may be able to sell it right after that first spouse died and not pay any income tax. The third thing we're concerned about is the estate tax rules. Currently, most of our Texas residents don't have a problem with estate taxes because in the year 2014, you can pass away $5,340,000 totally estate tax free, free of federal estate taxes, and thus also free of Texas inheritance taxes, of which we don't have any right now. Another thing that we get concerned about with estate planning is income taxes. We talked about income taxes or capital gains taxes on the sale of property. However, a lot of married couples find that upon the loss of the first spouse, the surviving spouse has to pay a whole lot more in income taxes than what they did when they were married. Why is this? Because the surviving spouse is a single individual and gets in the higher tax brackets at about half the income. And if the income from the married couple comes from passive income sources, such as rents, royalties, interest, and dividends, the surviving spouse may have just as much income, but get into a much higher tax bracket very quickly. A properly planned estate can save a bunch of these income taxes. The other thing we're concerned about is when we pass property on to our children, such as if we pass a farm or ranch on to our children, when the child farms or ranches it, he or she has to pay Social Security tax on the income received on that property. If, though, we put that property into a trust, we would save the taxes. We might be able to save this Social Security taxes on the income when the child earned it, either by running the farm or the ranch. A couple of other taxes we'll talk about later. One is the gift tax. Of this $5,340,000 I talked about earlier, you can use some of that against your gift taxes during your lifetime. Let's say you give away $3 million worth of property during lifetime, and you'd have then $2,340,000 left over to use against your estate taxes at death. The other concern we have about gift taxes, though, is the annual gift exclusion, and that in 2014 is $14,000. You can give to anybody, no relationship required here, a gift of up to $14,000, and as long as it's a complete gift, so the beneficiary can do with that $14,000 of either cash or securities or property, whatever he or she wants to, there's no tax reporting, no tax issues, it just is totally tax-free. And the last thing we want to talk about is generation skipping tax. That's one more tax we need to mention a little bit. A lot of people say, my kids are already well enough off, I want to give it to the grandchildren. Well, if you give too much, which is defined as the estate tax exclusion of $5,340,000, there may be a generation skipping tax that will be due either when it goes to the grandchildren or when it comes out of the trust for the benefit of the grandchildren. Those are some of the laws we'll talk about in this estate planning series.